Okay, welcome back. I hope everybody that's joining us had a chance to get a quick lunch. For those of us in the Pacific time zone, it's not even lunch yet. It's still early, but nevertheless, we're going to just jump right in with the program. We've got a great presentation for the lunch hour, and presenting is Jennifer Horne Huntsman. She is with Holland and Hart, based out of he'll probably talk about this, but out of the Salt Lake City office. And brief bio on Jennifer, she works with clients on a broad spectrum of environmental matters across a variety of transaction types involving renewable energy projects, brownfields redevelopment, real property acquisitions and leasing, mergers and acquisitions, and divestitures and financing. She also represents clients in complex environmental and real estate matters, including circular litigation and land use disputes. So I've given you sort of the standard bio background. So Jennifer, thank you for joining us. Feel free to talk a little bit more about yourself and your background and your firm and your involvement with the environmental community. And I'm going to turn my camera off and sit back and enjoy the presentation. So thank you.
Great. Well, Greg, thanks. It's such a pleasure to be here. That was a great introduction. It makes it sound so very complicated. When people ask me what kind of law I practice, I say I'm a dirty dirt lawyer. So I work a lot with our commercial real estate lawyers, and also we have our energy lawyers, mining lawyers, anybody who's developing property that's got some complications from an environmental standpoint. I'm sort of the subject matter on the deal. I practice out of, as Greg said, out of the Salt Lake City office, but I work with my colleagues and clients at sites sort of throughout the Intermountain West, including in Idaho and beyond. And I think, those of us who are working in this sort of brownfields arena, we get to do the coolest stuff. We do great work. We get to work on projects that are transforming property from blight to productive, safe, and sort of profitable parts of the community. I think it's exciting. We've worked with municipalities, with developers and property owners, and my job is to help navigate the sort of legal environmental complexities of repurposing property that's been impacted by historical contamination. And then most importantly, and in some ways the most fun, kind of puzzling through how to manage what can be enormous potential long-term liability, but it doesn't have to be. We've developed, working with clients and colleagues, we've developed solar projects on active Superfund sites, multi-family housing developments at most recently at a former steel manufacturing plant that before construction started looked like you could never imagine that a gorgeous little set of townhomes was going to be located on this property that looked so industrial and so impacted. And hotels and resorts on former mining lands. It's cool stuff that we get to be a part of. So I'm going to talk today about legal perspective, liability, and risk management considerations in projects like this. So I'm hoping that this can be, as much as we're constrained a little bit by the format here, I'm happy to answer any questions. I think if folks put questions in the chat, then I'll hopefully, if I notice them, be able to answer them along the way, or we can ask questions at the end, whatever works best. So I think I'm going to start by sharing my screen, if I can figure out how to do this right. There we go. Hopefully folks are seeing that. If not,
looks good.
A message. Perfect. Okay, thanks, Greg. Okay, so today I'm going to cover, assuming we've got time, depending on how the questions go, I've got 5 key questions that I want to talk about. The first one is for developers and owners, when it comes to environmental liability, how scary is it really? Question 2, what are the key liability risks? For a lot of folks here, that's going to be a little bit of a review, just kind of an overview, kind of reorienting folks about kind of what the specific risks, legal risks are that we're thinking about. Question 3, how much due diligence is enough when you're looking at purchasing property or getting involved in a project? And that we're looking at more from the buyers or investors or developers perspective. But it impacts sort of everyone involved, including, I think, the agency when we're working on a voluntary cleanup program or remedial action plan with some agency oversight. Question 4 is BF, is bona fide prospective purchaser liability protection sufficient? You're going to find out the answer to that. From my perspective is it depends. And question 5, if we have time, considerations in allocating liability risks in between parties to the transaction. So between buyer, seller, investors, in the actual purchase and sale agreement in the transaction documents. So let's get started with question 1. For a developer, are the environmental liability risks really all that scary? I think the answer is yes. But the good news is Congress and state legislatures are mostly on developers and owners, the side of developers and owners. Specifically, there are some good, as folks here know, good statutory liability protections that apply in many cases. The key is to be eligible to qualify. You've got to take specific steps before you purchase the property, especially, and then in terms of continuing obligations afterwards. The key for developers, investors, and lenders when we're looking at developing property on environmentally, with a little bit of a past with environmental impacts is certainty. So when we're looking at a deal and looking at managing the environmental liability, the risks, we're looking to create as much certainty as possible. It's all about that pro forma if you're the developer. So certainty doesn't just mean no risk. Certainty means specifically when we're looking at the deal, how clearly does the deal pencil out? How clearly can we quantify what the risks are, what the costs are going to be, how long it's going to take, so that we can decide whether this development is going to be feasible and how best to go about it. Whether financing, whether and when we can bring in financing, things like that. We'll talk more about that. Good due diligence, of course, can help eliminate the surprises and help the developer investor know whether a given property is going to pencil out. A good environmental consultant on board from the start of a deal is worth his or her weight in gold. It's hard to do good due diligence without a really qualified environmental consultant who's giving very frank advice. Okay, next question. What are the key liability risks for a property owner, developer, or future buyer? And no matter where we're coming from, whether we're on the agency side, we're on the developer side, we're on the seller side, environmental consultant, lawyer, it's important to understand because what we ultimately want to get to is a property that is cleaned up, redeveloped, ready for reuse, and profitable. So understanding what that ultimate owner, property developer, future buyer, what their key liability risks are, helps us know kind of how to best manage it as we go. And let's move forward instead of back. Here we go. Okay. The answer is we're looking, of course, this is kind of where I live. That's in CERCLA land and state hazardous substance laws, which we sometimes refer to as mini CERCLA laws, both of which provide private causes of action for third parties. So under CERCLA, we're dealing with strict joint and several liability that's retroactive. There's no equity involved in strict joint and several liability. CERCLA kind of doesn't care what's fair or unfair. That's a concept that for those of us who work in this area on the agency side or the environmental consultant side, or developers who have some experience, that's a concept that we're used to. But for a lot of developers or property owners, the notion that you can be held liable for contamination even that existed long before you got there, that you had nothing to do with, and you've been a good environmental citizen, and you could still be jointly and severally liable for cleanup costs, is a really hard concept to get your head around. It doesn't feel fair, and it's not much like how most laws work. Usually we're looking at, we're looking at some level of culpability. Obviously with CERCLA, that's not the case. Federal, state laws, let's talk about CERCLA again for just a minute. I was going to say, and maybe we'll get to this in the slide, but state laws for them vary from one state to the next. Generally speaking, state laws are less, few state laws impose the same kind of strict joint and several liability that CERCLA does. Some do. Most are a little less draconian, but just about every hazardous substance CERCLA-like state act is going to impose some level of liability on a current owner or operator of the property, or an owner or operator at the time that the disposal occurred. But let's get back to CERCLA, the sort of scary place where we're dealing with strict joint and several liability. We've got 4 classes of potentially responsible parties. The 2 that we're thinking most about when we're thinking about property redevelopment and the 2 I'm going to focus on today are owners and operators at the time of disposal. So whoever owned or operated the property at the time that the hazardous substances were released there at the property, and then current owners and operators regardless of how and when the contamination occurred. If you happen to be the owner of the property at the time that that the hazardous substances become an issue, are discovered, need to be cleaned up, you are in that circle of, you're squarely in the circle of potentially responsible parties. State laws, as I said, vary from one state to the next. So question number 3. So that sort of gets us to, for a lot of folks, that's a review, but that sort of gets us to what we're thinking about mostly when we're looking at liability for environmentally impacted property, for hazardous substances, for cleanup. There, of course, are other environmental statutes that impose liability, Clean Water Act, RCRA. There are permitting requirements depending on what sort of development you're doing that originate in various environmental laws, the Clean Air Act. But what we're thinking about mostly when we think about liability in purchasing property, again, is CERCLA liability. So question 3, what's the right balance to strike in due diligence? So this becomes a question, especially in a market like we have in a lot of areas right now, a super hot market where sellers of property have a lot of leverage. They want to get a deal done quickly. They may have multiple interested buyers, and where you've got environmentally impacted property that's going to need some work, as a seller, you may be interested in sort of getting the deal done as quickly as you can, limiting how much due diligence is going to be done, letting the buyer or developer sort of take on the risk. But from a buyer's perspective or a developer's perspective, how much due diligence is the right amount of due diligence is a different question. I think it's an unusual case where you want to, it's sort of I think an old school notion. Folks are becoming a little more aware of kind of how this all works today, but we still occasionally work with buyers or developers who say like, well, I don't want to look because I don't want to know. If I don't know, I don't have to report it. We can sort of go on our way. That's rarely an approach that we recommend for a lot of reasons. Obviously, knowledge is power when it comes to due diligence, but let's talk about some specifics. So how much due diligence to do depends on your risk tolerance and the end use. If you are looking at former industrial property and you want to convert it to residential, you want to build multifamily housing, you're going to need to do a lot of due diligence, much more than you might if you were keeping the use the same and doing a sort of simpler redevelopment. When we're talking about brownfields redevelopment, we're usually talking about former industrial property or property that's somehow been impacted, obviously. And so we want to think about good, thorough due diligence. There's almost never, and I think I'm preaching to the choir with this audience probably on this one, but it's an issue that comes up over and over, particularly in certain kinds of industries. There's almost never a reason not to do an ASTM compliant phase 1 ESA. No matter how quickly, if you've got, our environmental consultants are in high demand right now, they're very busy, but you can usually get a phase 1 done in a short period of time. It's just a great, it not only gives you good information, but more importantly, it's necessary for qualifying for liability protection, as we'll talk about. There's almost never a reason not to do one. Due diligence, all about discovering what lies beneath. The goal of due diligence is to eliminate as much uncertainty as possible, from my perspective. If you are a purchaser or a developer, you've got 3 key things that you want to learn during due diligence. 1, what are we dealing with? What are the conditions? And that's really about what's there, where on the property is it, where is it coming from, and when did it get there? The second thing, major thing we want to learn is how much will it cost to address it? And the third is how long will it take? Those two questions, those second two issues, again, we're going back to my mantra, which is it's all about the pro forma. In order to attract investors, to convince lenders to provide construction financing, if you're working with financing, you've got to be able to quantify the sort of what it's going to take to get the property in the to a developable state. And due diligence is sort of those are key goals for due diligence. So again, review, I think for a lot of this audience, first issue, what are the conditions at the property? So we're looking, of course, at what are the constituents of concern? Are they in soil, groundwater, surface water? What does it look like? What's the history of the property? And importantly, what institutional controls are already in place? And what do they mean for your planned use? If we're thinking brownfields redevelopment, we're generally going to take a property from one use and convert it into something else. We're going to repurpose it. Are there institutional controls in place that are going to impede your planned use? And if so, you're going to think carefully about what it's going to take to what needs to change, what cleanup work is going to have to be done in order to change those. You know, I want to talk here about no further action letters, because this is something that comes up in deals a fair amount of the time. A no further action letter, no further action letters are not all equal, obviously. You can sometimes get some good mileage with a lender or an investor by showing them a no further action letter that corresponds to, you know, something that's been identified in the phase one, or if you haven't done a phase one, you know, something that exists at the property. But the trick is to look closely enough, and again, a good environmental consultant is going to help guide you through this, to look closely at what that no further action letter said and on what conditions it was issued. Because you may, if you have a gas station, you may get a no further action letter because the agency determines that the property is safe for that use. But if you want to build housing, you know, multifamily housing on top of that, you know, that former site, you might get a very different answer from the agency. That no further action is always contextual, right? It's always context specific. So it always relates to what the use was at the time. And if you look closely, you can determine whether contamination was left in place that might now need to be dealt with, even if you're not changing the use dramatically, even if we're not going to a more sensitive use, you're going to have to be moving dirt around, and you need to know whether that dirt is impacted or not. So the next part of the, you know, discovering what the site conditions are is, where is the contamination? Not just where on the site is it located? Is it widespread? Is it, you know, pretty isolated? But where's the source? If we're talking about, of course, if we're talking about pretty isolated soil contamination that you can solve with a dig and haul, that's one question. It's much easier for your consultant to be able to give you an estimate, a pretty accurate estimate, but what it will take to deal with it. If we're talking about an ongoing source, so now we're getting into the next issue, these are pretty interrelated, which is when. If we're talking about an ongoing source, that might be a different story. So if you are, let's say you're a purchaser of property, or you're coming in to redevelop some property, and you do your phase one and you check all the boxes we're going to talk about in a minute to make sure that you have qualified for bona fide prospective purchaser liability protection. And you're ready to purchase the property, you may well have some defenses against liability for cleanup costs, but you cannot step into a property that has an ongoing source that's continuing to cause impacts and look the other way and not address it. So if you've got an offsite source, if you have some contamination that has no ongoing source, it's just sort of there, it needs to be cleaned up, that's not a difficult, depending on what the contamination is, that's sort of in some ways a manageable scenario. If you have an offsite source, let's say you've got a dry cleaner on an adjacent property, there's some groundwater contamination and happens to be migrating to your property, that's a different liability scenario. Not great, but also not worst case scenario. If you have a dry cleaner formerly located on your property, on the property you're interested in redeveloping, and you've got soil contamination that, I'm not a technical guy, so the consultants could sort of probably give us a better description of this, but you've got soil contamination, you've got dry cleaning solvents in the soil, touching groundwater, sort of continuing to cause groundwater contamination. You may, depending on the agency's perspective, have what the agency would consider an ongoing source, an ongoing release, in which case that's a different story. Now, if you want to come in and redevelop the property, it's likely that, depending on the state laws, depending on the agency, you're going to need to abate that source. You're going to need to get rid of the source and then deal with the groundwater contamination, for example, before you can redevelop it. So very different scenarios from when we're thinking about what it's going to cost and how long it's going to take to clean up. So, and then the other question is, where is it going? If you're dry cleaner, if you've got a source on site and it's migrating off property, now you've got to be thinking about third-party liability protection as well. That's when BFPP liability protection is going to be super important.
Jennifer, this might be a good time for a question that was from Eric Trainer. He said, Idaho has an innocent landowner policy, not in statute or rule, for adjacent property owners impacted by contamination from adjacent property, usually groundwater contamination. How would you view that if representing the impacted property owner?
So if I'm representing the impacted property owner, are we talking about an offsite source?
It said, yeah, by contamination from an adjacent property, usually property.
Yeah. Well, so those liability protections, we're going to talk a little more in a few minutes about the bona fide prospective purchaser liability protection, just because that's the one that comes up a lot when we're talking about purchasing property. But innocent landowner is another important liability protection. How that applies in each state is a little bit different. There's an innocent landowner liability protection under CERCLA as well. So I'm going to talk a little bit generally about it. But depending on what your state law says or what the federal law says, you first have to establish that you are eligible for that protection. So if you're an innocent landowner and you can check all the boxes, you can show, and the burden is on you, generally speaking, as the property owner, as the innocent landowner, to establish that you're eligible. And there's a number of criteria. For example, typically, it's something like you don't have you obviously can't have caused or contributed to the contamination that's coming from offsite. So you have to show that the source is not on your property and that you haven't done anything to exacerbate it. You have to show that you don't have a relationship, that you're not affiliated with the adjacent property owner where the source is. And in some cases, for example, with CERCLA, you also have to show that you conducted what CERCLA calls all appropriate inquiry before you, which we'll talk about in a minute, before you purchase the property. So assuming that you can show that you meet all of the statutory criteria to be considered an innocent landowner, then you've got that's a great scenario, because now you've got some good protection against liability for having to clean up the contamination even on your property. You may, depending on the circumstances, have a cause of action against the adjacent property owner if you do take action to clean up. Let's say that you need your development to move forward, right? So you and the adjacent property owner is not taking necessary steps to get it cleaned up. You don't want to hold up your development. You may undertake the cleanup, and then depending on a number of factors, you could have a cause of action to recover the cleanup costs from that other party. But the good news is, if you qualify as an innocent landowner, you're not going to have to go sort of abate the source, right? The trick is that in general, as a property owner, you have to, if you have, and again, this is specific to CERCLA, but it applies at least in some ways generally in most states as well. You have continuing obligations as a property owner. So you essentially have to be a good environmental steward, and you have to prevent exposure of existing contamination to human health and the environment. Well, specifically you want to prevent exposure to humans. So if you know that you've got contamination migrating from another property and you're planning to excavate your own property, undertake construction, you may still have some liability exposure, not just under environmental laws, but under tort liability as well, if you don't take measures to disclose and protect your work with your contractor to make sure that the workers are protected from exposure if it's something that's hazardous. And if you're going to build, for example, residential housing on that property, you may still need to look at ways to mitigate the effects of that contamination. So for example, if it's a dry cleaner scenario, you've got groundwater contamination that has migrated onto your property right where you want to build a lovely townhome development. And the groundwater is shallow enough and the conditions are such that you have a vapor intrusion issue from the dry cleaner solvents at a level that your environmental consultant explains to you could cause a risk, right? It's too high for indoor air, for healthy indoor air quality. You may need to take steps, for example, that your environmental consultant can advise you on, installing a vapor barrier, for example. There may be some other measures that you have to take that fall far short of having to clean up the other guy's problem, but you still have to take some steps to protect folks who are going to be using your property. So it's not great. It's never great news when you know that there's contamination that's impacting your property. Much better news if you are in a place that has an innocent landowner statute, innocent landowner defense, and you can qualify for that defense. That was a long answer. Did that address the question? Any follow-up?
I think so. If not, Erica, repost a follow-up. Thanks, Jennifer.
Sure. Okay, so we've talked about we're talking about due diligence. So we're worried about the cost of the cleanup, and we'll talk a little bit later, assuming we have time, about sort of how to clarify the transaction documents, who pays for what, when there's cleanup that has to be done. The other question is, how long will it take to clean it up? Key question is, can the development proceed in the meantime? Are we dealing with groundwater contamination and your environmental consultant can suggest a means of groundwater remediation that can happen in the background while development can move forward and you can still use the property? Or is this remediation that has to occur before the development can really begin? So there are, when you're dealing with brownfields redevelopment, there are going to be some key milestones when we're thinking about if you are looking at private financing. And these key milestones are all about whether things are going to pencil out from a financial standpoint and whether you can get your lender comfortable. We've worked with clients who are working through a state voluntary cleanup program, which can be a great way to give your lender comfort and to sort of get some good assurances both for you and for future owners, help make your property much more marketable. But there are some catches. There are sometimes some complications when you're dealing with a financer, because you've got to get to, depending on how conservative your construction lender is, they may want to see the approved remedial action plan, right? That approved cleanup plan before they're going to feel comfortable lending money on the project. And depending on the site and the demands on the agency at the time, it may take quite a bit of time before you can get to that approved cleanup plan and everybody's on board with exactly what has to happen with the site. So depending on when you need financing, that can be a little bit tricky. Whatever written acknowledgements, and this varies by agency, but when an agency is willing to give sort of written acknowledgements or whatever you can get on paper along the way that shows that you're proceeding, that the agency is engaged, and that you're working toward what's going to be a manageable cleanup plan, the better from a financer standpoint. All right, so moving on. What next issue is let's see. No, I just moved backwards. One moment. I need an environmental consultant to run my slideshow, I think. Okay, so question number 4. It's a phase 1 environmental site assessment and bona fide prospective purchaser protection or innocent landowner protection enough at a brownfield site. I am a huge advocate of qualifying for BFPP liability protection and taking whatever steps your state statutes provide to get some assurance. But I think the answer is it's not always enough. It depends on the site, at least from an investor and developer standpoint. If we're talking about a run-of-the-mill commercial development or a fairly straightforward site with some soil contamination that can be solved with a dig and haul, BFPP defense, your phase 1 environmental site assessment, and all appropriate inquiry are golden, right? It's highly valuable. It can give some really good assurance, assuming that you've done things correctly. But at a highly impacted site, you might need to expand the toolkit. And I'm going to talk just briefly about some other options that are available that some folks here have probably used before and may have talked about a little bit today to help expand that toolkit when you need more assurance either for yourself or for your investors and lenders at a highly impacted site. So let's talk about self-implementing liability protections. So bona fide prospective purchaser liability protection and innocent landowner protection under CERCLA and under many state laws, not all of which call, not all states refer to it as bona fide prospective purchaser, but they may, like Idaho, have some variation on that. These are generally self-implementing. So that means that there's no agency involvement on the front end. So you don't go to your local DEQ or EPA and get a sort of certification that says something in writing that shows that you have qualified as an innocent landowner, a bona fide prospective purchaser, which is, I should say, as many folks here know, if you qualify as a bona fide prospective purchaser or an innocent landowner, that is a defense to joint and several liability. It's a defense to liability for the existing contamination that you didn't contribute to. So if there's contamination existing at the site that was there, before you got there, if you can show that you're a bona fide prospective purchaser or an innocent landowner, you won't be liable for the cleanup of that contamination. Though, as we described a little bit before, there may be some other complications, but you're not going to be jointly and separately liable for the cleanup. So these are, so the fact that it's self-implementing is great in that it makes it very efficient. It's kind of accessible to anyone who qualifies for it. And we'll talk about what the steps are that you need to take before you purchase the property. But essentially, as long as you can show that you checked all of the boxes prior to purchase and that you otherwise qualify for the liability protection, it's there, it's in place. You don't need a stamp of approval. The drawback to that, though, is when you don't, the con is the same as the pro, no agency involvement or official stamp of approval. So that means that you've got to be really sure that you've followed all the steps, which we'll talk about in a minute, because it can't be fixed retroactively. If you have missed your window to take the steps that you need to take in order to qualify prior to purchase, prior to acquisition, you have missed the window. You may have other sort of defenses to joint and several liability, but nothing like the sort of protection that you get as a bona fide prospective purchaser or innocent landowner. Courts are a little bit all over the place about this. So the way it works is someone, an agency or a third party comes to you and makes a demand for cleanup costs. So someone may file a lawsuit for cost recovery or contribution for cleanup costs that they incurred at their site or at this property, say a subsequent owner, or an agency may try to initiate an enforcement action and impose the cost of cleanup on you. You say, oh, actually, I have a defense to that liability. I'm a bona fide prospective purchaser. Here are all the steps that I took. Here's evidence that I complied, that I'm eligible, and that I have maintained that liability. And if that goes before the court, that your evidence that you qualify is going to be scrutinized. Courts are a little bit all over the place about how strictly you have to comply with the requirements in order to qualify. So that's one drawback, right? You don't have, because it's self-implementing, you got to kind of trust that you've done an effective job of not only complying, but also documenting, maintaining that documentation long-term so that you can prove it, because the burden of proof is on the person the party trying to claim that liability protection. Because it's self-implementing, there's no sort of official document, there's less perceived assurance for investors, lenders, and purchasers sometimes, depending on how convincing the environmental attorney is about it. So we talked already, CERCLA's liabilities join several strict retroactive. We talked about potentially responsible parties. We talked about the good news, which is that BFPP, bona fide prospective purchaser liability protection, innocent landowner protection under CERCLA is available to both. When I say both here, we're talking about owners and also commercial lessees, who in some cases can be held liable as if they were an owner. So in order to qualify for these liability protections, these statutory liability protections, you need to know how to qualify, how to keep it. Because this is review for a lot of folks here, I'm going to just quickly go through the steps. First, how to qualify. CERCLA calls the steps that you need to take all appropriate inquiries. And all appropriate inquiries are all about a phase 1 environmental site assessment. That's not all you have to do, but that's sort of the beefiest part of it. So and this we need to update because we have a new ASTM standard in place, but there's a specific ASTM standard, E152713. And now as of this year, we have a new ASTM standard. So for the moment, until EPA officially adopts the new standard, the old standard is in place. They're fairly similar, some differences, but essentially you need a phase 1 environmental site assessment completed by a good qualified environmental consultant that fully complies with the ASTM standard. Timing matters a lot. It has to be, the phase 1 ESA has to be done prior to, this says lease execution, but prior to the time that you acquire the property, if you're purchasing it, and less than 180 days before closing. The other thing is you have to get, and if you've got an older phase 1, if it's within a year, you have to at least have updated that phase 1 180 days prior to closing. To update a phase 1, your consultant has to redo some of the big components of that phase 1. So it's not exactly like redoing a phase 1, but it's almost like totally redoing it. You have to, and it's important that you get the name right. So the phase 1 ESA must be, and this is a point that not all folks agree on, but I think is a critical one, and it's an easy one to get right. A lot of folks get it wrong. You have to get the name right on the phase 1 ESA. The phase 1 has to be issued to the party that is trying to claim liability protection. So typically that's the owner, so the entity that's going to take title to the property, or if we're talking about a commercial lease situation, the lessee. And we want that party to be the user. User is a specific term. It's a defined term in a phase 1 environmental site assessment, like a lot of folks here know. The party who needs a liability protection needs to be the user, not the reliance party. So there's also a paragraph in a phase 1 that discusses who can rely on the phase 1 environmental site assessment. It's typically the user, the client. Sometimes that's expanded a little bit to the lender or other parties. But some folks, but a reliance letter is not going to fix the problem if you have a phase 1 that's issued to some other party. Let's say another interested buyer or the seller, for example. Sometimes a seller will get a phase 1 prior to marketing the property, and they'll serve it up to the real estate professional and say, look, we've already got a phase 1, you can skip that step. Number of reasons not to skip that step. The biggest is that you can't use someone else's phase 1 to satisfy your own all appropriate inquiries and qualify as a bona fide prospective purchaser. You can have the environmental consultant reissue that phase 1 to you, but I would not use a reliance letter for that purpose. A reliance letter is a letter from the consultant that says you have permission to rely on this phase 1 ESA to the same extent. The terms are a little different, but generally to the same extent as the party to whom we issued it. The reason that isn't sufficient for satisfying all appropriate inquiry is because the concept of all appropriate inquiries is that the person purchasing the property, qualifying, has to participate in the process. And that includes filling out a user questionnaire that your consultant is then going to incorporate into your phase 1 environmental site assessment. If you just have a Reliance letter and you haven't completed that user questionnaire, and that user questionnaire, the answers haven't been incorporated into the consultant's assessment and into that report, you haven't satisfied all appropriate inquiry, at least according to some sources. So get your own phase one. And then have your favorite environmental lawyer review the draft. Because some courts take a fairly relaxed view of a phase one environmental site assessment and say, look, if you've taken the major steps to do your due diligence, that's good enough. That's not what the statute says. It's also not what some courts have said. Some courts will apply great scrutiny to the phase one ESA down to sort of the letter of the law. So it's very worth your time to have counsel review the phase one report before it goes final, just to make sure that all of the boxes are checked for the ASTM standard. Okay, in the last few minutes that we've got, some common pitfalls. We've already talked about most of these. Relying on someone else's phase one environmental site assessment to try and qualify for liability protection, not a good idea. Phase ones that are not ASTM compliant. We've talked about timing. They have to occur pre-closing. There's no way to remedy that retroactively, but the shelf life of a phase one is limited. So early may mean often. In other words, if you are investigating a property, you're doing your due diligence, and that due diligence period is going to extend beyond 6 months. If you do the phase one early on, you've got to watch that the shelf life carefully. You may need your consultant to update that before closing so that you're sure to comply with all appropriate inquiry. Another pitfall, and there are two ways to look at this, and every deal is different, but in general, so this doesn't apply always. In general, using the other guy's environmental consultant, is not advisable. So one reason is, or relying on, a phase one done by the seller's environmental consultant. This is a little bit of a controversial point. Again, sometimes it works great. We have done that with clients in some deals, but in general, a recognized environmental condition, we call it a REC in a phase one ESA, is not always a REC. The ASTM standard, even when you have two very good environmental consultants, again, I think a consultant could argue this both ways, but what I've found, having looked at these in lots and lots and lots of deals, you can have two excellent environmental consultants. They can look at the same property, the same information, and especially under the old standard, there is a fair amount of professional discretion involved. That's why we need a good qualified environmental consultant conducting the phase one. One environmental consultant might consider a condition, a recognized environmental condition that's going to be noted in the phase one environmental site assessment that may require some additional investigation. Another great consultant is going to see it differently, not consider that a REC. It's always most helpful to have your own environmental consultant who understands your risk tolerance and he can have a really frank discussion with you and doesn't sort of have divided loyalties about, sort of whose interests they're representing. Just like you need your own lawyer in a deal, in some deals, having your own environmental consultant is important. So those are some common pitfalls. Continuing obligations. Once you've qualified, I'm going to cover this very briefly because we could talk a long time about this. But once you've qualified as a bona fide prospective purchaser, you will need to maintain that by complying with what the statute calls continuing obligations. That basically means don't mess it up. So in other words, you need to take reasonable steps to stop continuing releases of hazardous substances that are happening on your property, prevent future releases, prevent or limit human exposure, environmental, natural resource exposure to prior releases, taking reasonable steps, as we talked about a little bit. What the continuing obligations are going to be at any given property will vary depending on the conditions. Beyond BFPP liability defense and innocent landowner liability defense, at a highly impacted property, as we discussed, it might be difficult to get your lenders and investors on board with just assuring them that you've got a good phase one and someday could raise the BFPP liability defense. State voluntary cleanup programs. Some states offer written assurances that they can provide kind of like a comfort letter in advance. Not all agencies can do that, but some offer that option. That, though they don't offer, though a written assurance might not offer additional protection, legally speaking, can certainly offer more assurance with for your lenders and investors. One reason for that, I think, is that it shows that you have engaged the agency, that the agency is aware of the conditions of the property, and that there's not some, sort of hidden issue that could come to the attention of the agency later, and there could be some sort of enforcement action. So we don't have a ton of time, so I'm going to talk about these very quickly. EPA comfort letters, if you're dealing with a site that's had any federal action or that might have some interest of EPA comfort letters can be a very useful tool for future buyers, owners, and investors. They're basically a letter, as a lot of folks probably know, that again, it's a way to engage the agency. They sort of talk about, generally speaking, the EPA will have model comfort letters that they use, and the letter will come from the EPA, but it's the recipient of the letter, working with a good consultant and counsel, who should make that first draft. Because within that comfort letter, there are EPA will talk about the property, sort of what information you have provided EPA about the property, and then they'll talk about reasonable steps that should be taken at the property to sort of from the EPA standpoint, from the agency standpoint, and the recipient of the letter, who will know that property well because of their good due diligence, can generally suggest some good sort of reasonable steps that are customized, that are sort of tailor-made for the property. Those get more and less specific depending on the comfort letter. Always good to propose that to the agency. They appreciate the effort, and then those can be negotiated, and you sort of put forward what you think makes the most sense as sort of the opening of that negotiation. Something that is less common, whether it's available kind of varies by region, is it's sort of a comfort letter from EPA on steroids. It's a removal action comfort letter where a property is going to be redeveloped, where there's going to be sort of additional work done at the property. You can get a more specific comfort letter from EPA. Again, not every region, but we've seen these coming out of Region 3 recently, for example, that kind of that will get more specific about what steps you need to take in order to not run afoul of any institutional controls or sort of or requirements EPA think should apply at the site in order to avoid incurring liability. And then ready for reuse determinations if you're dealing with a Superfund site, and that site is the portion of the site that you're interested in developing. It's far enough along in the process, the characterization has been done, EPA is comfortable with the conditions of the property or with whatever sort of institutional controls are in place there about how soil is handled, about whether groundwater can be used for certain purposes and that sort of thing. You can get from EPA, if your lender or investor thinks it's necessary, a ready for reuse determination that is specific to that property. It's basically a statement by EPA, again, providing information about what's been done, what the conditions were at the property, and a statement that this property is ready to be redeveloped. So those are, again, tools that don't necessarily provide a lot of extra statutory protection per se, but they can provide a lot more reassurance. You can provide them to future buyers who can at least see that agency engagement has happened. So question 5, I think we're just about out of time. So we may not.
Yeah, but you take a couple minutes, and there are some things in the chat. I think Eric Trainer from Idaho DEQ mentioned that Idaho doesn't offer comfort letters. There's a couple other things. I think that there were just some information Eric was providing for attendees. But yeah, take a couple minutes. We can go through question 5. And this has been very, very good, Jennifer. So go ahead.
Okay, I'm going to speed through these. And then I'm happy to answer questions afterwards, or if folks want to email me. I think I'll put my email up here in just a moment to debate it, to ask questions, however I can help. So avoiding environmental liability through your purchase and sale agreement and other transaction documents. One key here is indemnity provisions. How survivability, so how long your If, for example, the seller is going to indemnify the buyer, if you're lucky enough to have negotiated that as a buyer, for existing conditions, for anything that existed pre-closing, for example. There are a number of ways to do that. That's one common way of allocating risk. You want to look closely at how long that indemnification obligation survives. Some indemnification provisions survive only for a set number of years, maybe a year post-closing, 3 years post-closing. Sometimes it's until the statute of limitations has run or some period after the statute of limitations has run. I always like to say when it comes to environmental indemnifications, nothing lasts forever, but contamination might come close. So there may be conditions at a property that won't be discovered until years and years down the line that existed at the time of closing that the seller should be responsible for under an indemnification provision. Make sure if you're the buyer that doesn't last too long. If you're the seller, you want the opposite. Think about limiting that to a manageable period of time so that you don't have this trailing potential for liability ongoing. Another important thing to put either in the indemnification provision, depending on how specific you get it, or if you have another provision in your purchase and sale agreement that provides for the cleanup of the property and some cost sharing, you need to think carefully about getting specific in the agreement about who handles what. For example, the contamination is going to be cleaned up, but to what standard? And when is it clean enough? Is that in the buyer's judgment? Is it in the seller's judgment? Do we have an agency involved? Are we in a voluntary cleanup program? And the agency is ultimately going to decide, does seller get to participate in the negotiation of the remedial action plan or the cleanup plan with the agency and with the buyer if the seller is going to be partially responsible for those costs? There are a lot of who gets to sort of be who gets to work most closely with the agency. So there are a lot of how much does the seller get to participate? A lot of specifics that need to be outlined in those transaction documents to avoid disputes down the line. So here, I'm going to throw up really quickly. Here is my email address and my telephone number. Happy to answer questions or discuss the issues anytime. And thank you so much for having me.
Jennifer, thank you. That was a very detailed, just sort of a deep dive. I feel like I was at some advanced legal workshop for myself. That was great. And I know having this presentation available after this conference will be very helpful for a lot of people that were like, wow, this is some really good information. So really appreciate the perspective and the information. Very helpful, very beneficial. With that, we're going to take I think it's about a 7 minute break and be ready to jump right back into the case studies. It'll be a 2-hour, sort of a rapid fire, if you will, look at 6 different case studies. So with that, we'll see you in the next session. And again, thank you, Jennifer.